This is the Court Leader's Advantage, a podcast series for court professionals and by court professionals. Brought to you by thecourtleader.net and in cooperation with NACM, the National Association for Court Management. Artificial intelligence, AI, is no longer just a futuristic concept. It's already reshaping how we live and work. AI is transforming the justice system in ways we could have only imagined a few years ago. Here's how AI's power is already making waves. Unmatched efficiency. AI can produce polished reports, memos, and articles in mere minutes, dramatically reducing the time and effort needed for routine tasks. Instant access to information. AI enables litigants, families, and other court users to engage in meaningful conversations about procedures without relying on human staff. Sharper decision-making. AI-driven insights are helping leaders make more informed, data-backed judicial and administrative decisions, and compelling presentations. AI tools are enhancing professional presentations and transforming complex ideas into easily digestible information for audiences. Yet with all this potential comes a need for caution. The NACM AI Guide strongly emphasizes the importance of training and comprehensive policies to mitigate risk while unlocking AI's potential. I'm Pete Kiefer, and welcome to the Court Leader's Advantage podcast series. This month, we'll tackle two critical questions. How can courts ensure they're getting the right AI training? And what does a comprehensive AI policy look like? Courts will need to answer these questions in order to harness AI's power effectively and responsibly. Joining me to discuss these issues are Stacy Mars, Administrative Director for the Alaska Court System in Anchorage, Alaska; Shay Cleary, Managing Director for the Court Consulting Services at the National Center for State Courts in Williamsburg, Virginia; and Tina Madison, Deputy Court Administrator for the Pima County Consolidated Justice Courts in Tucson, Arizona. Thank you all for joining today's podcast. A recent Pew Research poll has revealed that 35% of the public have a negative view of AI, and another 33% feel that its benefits are counterbalanced by its risks. This skepticism has led some to predict of a pending AI revolt, where society pushes back against this new technology. Courts, being conservative by nature, could they reject AI altogether? Could we see courts out of caution or reluctance simply refuse to adopt it, or at least ignore that it exists? Stacy Mars?
I think courts could ignore AI and wait until more is known about the risks before diving in to use it. But I think that would be a big mistake, because I think there are great efficiencies that can be had. And I bet employees are already using it, whether or not they want to sanction its use or have policies about it. I think it's clearly being used. I think we're at a place where there's been such extraordinary leaps and bounds in AI technology, particularly with generative AI. We haven't seen, and I'm talking more in its capabilities in society, and it's really embedded in so much of what we do in our everyday lives, that I think I'm surprised to see that number is that high with the Pew poll, because people are using it in their internet searches. It's like kind of built into so much. If you use digital assistants in your homes, if you do any kind of streaming of either music or movies or TV shows, if you do online shopping, social media, navigating in your car, ride hailing apps. I mean, it is just so embedded in everything we do that I'm a bit surprised to hear that there's a negative view, because I bet that a lot of people that have a negative view don't realize that they're using it every day. And what I'm most excited about is to see how it can be used in a really beneficial way in the court environment. We haven't seen a huge rise, or I have not been familiar with the huge rise in the technology that we use every day that really has the generative AI built into it. And I'm thinking there's going to be an explosion in the next probably 3 years. And I'm curious at the next Court Technology Conference if the vendor show is going to really be showcasing a lot more applicability. So I'm excited because I want to see where we can gain efficiencies in our operations. And also I personally find that I and my staff get a lot out of it, especially when you're just trying to brainstorm and just generate ideas. So I think that it would be a mistake to turn our head the other way and not use AI technology right now.
Shay Cleary?
I appreciate the question. And having been in court technology now for almost 25 years, AI absolutely has the potential to transform how we deliver services and the things that our courts can do. But it is another technology. And I look at other technologies that the courts have adopted and have been slow to adopt. And I think AI is the same way. For example, texting reminders. I don't know how many times I heard from people that they get a reminder from their dentist via text message. Why don't the courts do that? Going from paper to a paperless or paper on demand environment, tremendous change for the courts. And in my courts, we faced a lot of resistance to that. And as people trusted the technology and realized the benefits of it, it was adopted. And I think we're going to see the same thing with these AI technologies. The key to it will be trusting it. And I think that applies both to the courts utilizing it as well as to the public. When it works, it's amazing.
The NACM guide makes it clear that training is essential before a court can embrace AI. But how do courts choose the best training program for staff? What should be the key factors in evaluating a program's effectiveness? And how can courts set realistic expectations for AI's role in court operations? Tina Madison?
As the president for the National Association for Court Management, I'm really proud of the AI guide, and I'm glad you brought it up because it's a guide that helps courts look at what they should be considering, and training is a big component. When we looked at the guide, we said, what is important for people to know as an administrator, as an HR manager, as a technology, as an educator. So there's all these different components to the guide. But the training piece is, how do you even know what tool to use? I mean, where do you even start? And I think some of that is, looking at other states. What have they used? What are some of the companies? What are some of the vendors that are, already out there, and we know them. We're familiar with them. They're certified. They use the product. So looking at those things before kind of dabbling in it. But as Stacy mentioned earlier, we all use AI tools. So my court happens to be a Microsoft shop. So Copilot is embedded in our Outlook, in our email program. It's just there. And so training staff how to use it, they're already using it. It's more, to me, in my mind, how do we tap into that for more efficiencies, for more effective uses, to then drive it to the operations of the court? How do we streamline our documentation, our procedure manuals using these tools? And then it goes to, who's using it, and what tools should they be using? Like I said, Microsoft Copilot's in our system, but does that mean they shouldn't be going out and using Chat GPT? So I think there has to be some guardrails around what we're using it for, and really setting out that intentional. Are we doing it to be more efficient? What are we using the programs for? And then kind of building, and then how do you use the actual program?
Stacy?
We are pretty close to finalizing our AI use policy here in Alaska for court staff and for judicial officers. So it's an internal policy. And we have taken advantage of the long list of other states that have already created policies. So the National Center for State Courts website houses all these really valuable resources. So the AIRRT, or the Artificial Intelligence Rapid Response Team, of which I was a member, created a resource center that included a list of what other states are doing, including their guidelines and policies that they have set out. And so we have been spending several months internally reviewing all of the policies and then picking and choosing what seems to make sense for us and what gaps are missing, and then created our policy. So we've gone through 2 levels of internal review with we have a committee of judicial officers that are part of it. And now we have our clerks of court are reviewing the policy. And so we're very close to finalizing it. But I think having a policy is really important because it sets the tone for your system about what's acceptable and what's not acceptable. And the policy that we've created is pretty permissive. We're very encouraging of people to use AI tools, but we want them to be responsible and accountable. And we want them to make sure that they're also following other existing policies that are implicated by the use of generative AI. So I think it's important to take a lot of time and think about what you want your policy to accomplish, what you want your staff to walk away with. Do you want them to have real examples of things that they should be thinking about using AI for? Do you want to encourage them to play around? Do you want to identify specific things that they're allowed to interact with? So there's a lot there, and once you read through the other state policies, you get a real sense of it, because they're not all the same. There's a lot of differences. There's some commonalities. I think everybody is very mindful of certain risks, which are the fear of sharing confidential information or personally identifiable information that you learn through your job, and that we have drawn a really hard line, like not to put any of that information into any of the generative AI tools, because we definitely don't want that to be used to be training models that then could share inadvertently that type of information. So it's really important to think carefully about it. There's some really great resources out there. Tina mentioned the AI use guide that NACM and JTC worked on, which is very comprehensive and has a lot of information. Also, my professional organization, COSCA, which is the Conference of State Court Administrators, took the topic of generative AI for our policy paper that we put out last year on that topic. And we also talk about the need for such policies. So there is some guidance out there from different organizations at the national level that I think can really help shape policies.
Training and policy often go hand in hand. But which comes first? The AI guide suggests that courts need proper training before launching AI use. Yet training itself often relies on having a solid AI policy. Can you really adopt a policy before your staff is adequately trained? Or conversely, can you effectively train your staff without an overarching policy? Shay?
Peter, what you bring up here is definitely a chicken egg type question. And one approach that we recommend, and this came through the work of the AI rapid response team that Stacy had mentioned, is to start with an interim policy. And the reason for an interim policy is it allows you to get something out there quickly, which can grant permission for people to play with AI and learn from it within some set of boundaries. And you're setting it up so that once you learn more, you're going to probably have a more robust policy that allows for more use and more latitude, while also minimizing the risk. And it should match as tools adopt as well. And I think one thing that should be included in the interim policy is that there is training and training on the policy itself, especially when it's new. What's acceptable, what's not, what do you maybe need to talk to your supervisor before you do? What use cases are low-hanging fruit would be things like data that's internal only, or data that's public, and probably out of bounds right away would be anything that's considered sensitive or confidential or private.
Tina?
I appreciate Shay's comments about the policy and Stacy's about setting up those policies, and that I actually made me feel good that she said that they're just kind of getting theirs out. We literally just put ours out a couple of weeks ago as well. And I was afraid that we were like too slow out of the gate. Whereas I think a lot of courts are kind of in that interim realm. So Shay, I really appreciate that point. So it is a which comes first. As soon as I heard the question, I was like, whoa, which comes first? Do you train how to use it? Do you put a policy? But I love the concept of training on the policy. What does this actually mean to people, and what does it mean to the courts? But I do think there has to be guidelines for staff, because one thing that I found, and it was a perfect example for this conversation, our training staff held a webinar on how to get staff engaged with maybe some virtual trainings, and it was more on staff engagement, but the tools the trainer used were AI tools. And so the people that were taking the class was, what was that tool that you used? That was so awesome. I want to use it too. And it's like, whoa, 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 whoa. We haven't started using AI in our court yet. We don't even have a policy yet. So I think that was a perfect example of what we're talking about, which comes first. So we were showcasing a really cool feature, and people wanted to use it, but we didn't have anything in place that said, hey, here's how you can do it. And as the administrator, I'm like, and how much is this going to cost me? Because there's always a tool, there's always a cost to these tools for the most part, especially this AI tool was about gamification and using like little videos and scenarios, and trust me, it was cool. And I think that will be an advantage for some of our court trainers on training all of the things that our staff need to know to do their job. If we can find ways to incorporate AI, it would make our trainer life so much easier to get that information to our staff in a more engaging, more fun way of learning some of the material that we have to train on. So I'm glad for this question. It is definitely which comes first, the chicken or the egg.
I agree with things that both Shay and Tina said, and I do think you need the policy first, because then you can train on it. And I think what Shay mentioned is really important is this isn't, in my opinion, like a one and done policy, because you need to keep up with the technology. So as new technology and use cases and even risks and problems become aware, you need to update your policy. So I'll give you an example. While we had a really good draft of our policy, our tech department had gotten contacted because one of our staff members who remotes in on their phone to read their email on their personal phone, which is all authorized, had put an application on their phone to optimize their phones, which by doing that, and it was an AI tool, it went in and it got into their work email and their work calendar, and it deleted things and made changes. And so it made us go back to our policy and be like, whoa, you need to be really aware in your personal life, if you have that intersection between work and personal on any of your devices, that what you may choose to do with your personal applications, there may be impacts on your work applications. And so that caused us to change our policy a little bit to add language so that people had that awareness about that potential interaction. So I think it's just really important that, especially with an AI policy that has rapid change, that it's the kind of thing that you need to revisit on a regular basis so that you stay current with the needs as well as the benefits and the risks.
I didn't even think of that, Stacy. That's crazy to think that the tool is going in and deleting, cleaning up behind the scenes.
Yeah.
It was alarming.
What should a robust AI policy look like? Can we draw upon existing frameworks, or are they too scattered to provide any real guidance? For example, I've looked at various AI policies, and while some are clear about what AI tools are approved, for example, ChatGPT, Claude, or Bard, others have entirely different lists that include tools like Copilot and Gemini, and none mention tools like Grok, Perplexity, or DeepSeek. Should AI policies be tool specific? Should they just be generalized in their approach? Shay?
I think it's a combination of both. And you know, right now there really is not an existing framework that can be relied upon. Like we have similar to in cybersecurity, there's a number of different frameworks. And you know, it's relatively new. I mean, there are some standards out there with NIST and some others, but really there's not. So the process for developing a policy we recommend is first to, you know, get educated on AI, at least you know, at least have a baseline understanding of what it is and what its capabilities are. And then when you're developing that policy, make sure you're including a number of different stakeholders and seeking feedback from them. You know, you may want to get judicial ethics perspective in the creation of this policy, as well as your legal counsel. There may be groups that you bring to the table that you wouldn't normally. Then you need to make sure that, you know, if there are any state requirements around AI, for example, that you have to maintain an inventory. You know, often the judicial branch is exempt from what the legislative branch or executive branch states, but sometimes you may be subject to it, or you may want to, right? So, you know, a robust policy should include those statewide, any statewide requirements as well. And then you want to make sure that it gels with or interacts well with any existing IT policies. In many cases, courts have IT or computer use policies. Where can you utilize your court email address? Where can't you? You know, what websites are you allowed to go to, or even prevented from going to within your network? So it needs to consider those as well. And then you can't kind of get into the fun stuff, right? You know, what tools can you utilize? And one thing we're seeing here is there's a difference in terminology being utilized for different AI systems. I think Arizona maybe was the first court or state that started calling things sequestered and non-sequestered systems. The DC courts, they're just issuing their policy now. They're actually adopting that language as well. We've also seen courts use open and closed, as well as an enterprise system versus you know, a system that's more use case specific. And in most cases, though, if it is a closed system, it's something that's sequestered, it's something that's procured and paid for by the court, those AI tools have been vetted, and those are typically okay to use for a more variety of uses that you put in your policy. Those that are kind of newer or off the shelf, free, I think everyone's familiar with the statement that if you know, if the product's free, then you're the product. You're the one who's paying for it. So you know, really allowing a policy to be general and provide general guidelines that's going to allow people to experiment in a relatively safe environment. And again, we recommend two things. Start off with an interim policy because it may likely change, and we have seen courts who've issued a really restrictive policy where every AI use case or tool had to go through a committee, and it would get bogged down. So that's where general guidelines are a little bit better. And then require training on your policy as well as within your policy of utilizing AI tools. And I think those are probably the things we're seeing right now that make for a robust policy. The one other thing is to make sure people are adhering to it. Have some sort of measure in place where you're auditing to ensure that that it's being used. And if it's not and people don't understand it, make sure you're providing follow-up training.
Stacy?
So our policy is on the permissive side, and we encourage the use of these generative AI tools with important guidelines that need to be followed, like prohibited input of confidential information or PII. But we also make clear that the court system's other policies remain in effect, like Shay mentioned. You know, you can't download software onto court computers, confidentiality, don't plagiarize, don't share draft opinions or decisions. So we make it really clear that that is still in effect. But we did take, I would say, the generalized approach with our policy, but we did name products as well that we think are fine. So for example, we do subscribe to Westlaw Precision, which is, you know, got AI components. And so we're like, you know, well, if you use this, then, you know, think about this. We still say, even though Westlaw has assured us that it's, I guess you might call it a sequestered or a closed system, we're not entirely sure that that's true when we read the terms and conditions. So we do kind of advise folks that we think it'd be best to not put confidential information when you're using Westlaw Precision. But we do encourage employees to use the general AI tools like ChatGPT. We name a bunch, not exclusive, because there are things that we don't even know yet what they're called, or they'll change tomorrow. I do think it's important to provide use cases to your staff, though, the kind of things that we're talking about that we think could be useful to them, and some risks and where they want to use it. We do also talk about how to prompt effectively, because we think it's important for them to understand how to optimize their use of these systems and how to kind of iterate while you're using them, and not to, because something looks good, don't assume it is in fact right. Or and I think mostly about when I try to create images for some presentations or slides shows, and I'll say, oh, give me a picture of a courthouse with a mountain in front of it or behind it with an animal. We had an example that one of my staff was doing a training and asked for a courthouse with mountains, northern lights, a moose, and a bear. And it all looked pretty good until you realized that the moose had 5 legs, and there was spelling errors in the name of the courthouse. And, there's all sorts of things. It looks great, but you really have to dig in, and you got to use your most scrutinous skills to make sure that what you're getting is what you're asking for, and not just because it looks polished, that it's in fact what you want and it's accurate. So we spend a lot of time in our policy about the accountability piece, and making sure that if you use these tools, that in the end you have to own them. You whatever product is yours. You're vouching for it. And so you have to use all your skills to make sure that what you're getting is accurate. It doesn't, to the best of your ability, it doesn't contain bias, hallucinations. All the concerns that you have are things that you really need to be on guard for. But that, I think, to say these are all too risky and not use them is really going overboard, because it can really spur some ideas that maybe you didn't have. Maybe you don't even use the final product, but it gave you ideas in a way that you didn't have. And I'll share, when we created our policy, I had one of my attorneys worked primarily on it, and he did a great draft. I went and I hard edited it. And then once we had a good version, I said, I'm going to run this through some tools. And I did. And it gave me some better organizational ideas about how to format it. A lot of stuff, it came back, the rewrites, some of it I liked, some of it I didn't like, and I didn't incorporate, but it really gave me a different way of thinking about it. And we definitely took some takeaways from it, because it looked at it in a different perspective. So I think it's a mistake to be too cautious and to lock it down too much. And I would encourage people to use the free tools even.
Do you have anything in your policies about that human in the loop concept, that you should, that's part of the requirement, is that it's just not taken at face value, that there is some kind of human element for the edit? Is that part of your policy?
Yeah, that's a really good point, Tina. Yeah, it's kind of implicit through our entire policy that the human needs to be in the loop for pretty much everything, because it is the human whose work is ultimately the end product. And you have to be the one who reviews everything, and you're accountable for all the work you do. So human in the loop is a theme of our policy.
Thank you.
And I've seen that, and that's typically surfaced similar to what Stacy had said, where ultimately they're responsible for their work, and you own the output, and that's typically what we're seeing surfaced as being in the loop.
Finally, for courts that are just beginning their AI journey, what advice do you have for those looking to integrate AI into their operations? What steps should they take to start using AI responsibly? Tina?
And like I said, my court I felt we were behind everybody else in the nation, but turns out we're kind of in the middle. But taking that first step would be to look at all the resources that are out there. Both Stacy and Shay have talked about the NCSC resource web page. All of that information is out there. What states have what policies? Start looking at that. See how that would play into your court, and really define, what do you want to use it for? What are the needs of your court? Right now, I'm looking at court staff shortage, and I know there are courts out there that are utilizing AI tools to maybe help with some of the volume filings, and at least finding ways to just make us a little more efficient and effective with the work, the kind of the really task-oriented work. And if we could do that, I think that would be helpful. Look for those low-hanging fruits with low risk, and maybe start there.
Shay?
Definitely piggyback a little bit off of what Tina said. Understand the problem you're trying to solve or what you're trying to accomplish and how AI can do it. And then, I think it's prudent to, map out your business processes as well when you have a use case for AI, so that you can make it measurable, right? You can then tell people that you're saving X amount of hours over X amount of days, and that AI is making a difference. I've also heard that it's important to set realistic expectations. When people hear that you're going to utilize AI, they think, it's going to be fantastic. It's going to be great. So it's important to, especially when it's something new, kind of having a path and a slow release schedule where you're actually communicating and you're being really, you're communicating and being transparent with how it's going, and encouraging collaboration, encouraging people to try it. And I do also recommend starting with something internal, because you have a little bit more control over who's going to use it, and you can really encourage people to use it. It's a little bit safer if something's not working well, and you can just, kind of encourage that collaboration.
Stacy?
I think the first step is to educate yourself about AI and Gen AI, so that it's not this unknown scary thing. And as we've mentioned, there's a lot of useful tools that are available to the court community. We got the NACM AI user guide, the Casca policy paper. There's documents and webinars from the RRT on AI on the NCSC website. But there's also been, in the last probably 9-ish months or so, the Thomson Reuters Institute and the NCSC collaboration on AI, which has produced some really, I think, terrific papers and some webinars that are all available on the National Center's website. So there's a lot of information to get updated on what's going on at the moment in the court world. But I think the next step, once you have some understanding of this, is to develop a policy. And again, there's lots of resources to look at and figure out what is the appropriate use that your system is comfortable with. I think your policy should be really practical as much as possible. I think even giving some suggested ideas for use can really help staff who maybe have not used it to understand how it might be able to be beneficially used. Like, do you want to use it in helping to create interview questions, or come up with language? You're doing performance plans, or job descriptions, agendas. There's so many, concrete examples that you could use to help court staff. And then, as we've mentioned, I think it's important to encourage people to actually play around with it. Give them the latitude to try things, make mistakes in a safe environment, and understand limitations, what their comfort level, start to be very, skeptical and scrutinous about the outputs, so that you really show the need for the human in the loop. And then you'll start to see where it can be useful and where you can gain efficiencies, where you could brainstorm and see things in a new way, or solve some simple problems. And then once you have your policy in place, I think then you start doing training and come up with ways to test people's knowledge. We're going to make it part of everybody's requirements. We have, lots of different trainings that we require all employees to do, like cybersecurity training. I always have to put in a plug for that. AI use training is also going to be something that we're going to be requiring staff to do. So I think it's a comprehensive package, your policy and your training, and they fit really well together.
A huge thanks to Stacy, Shay, and Tina for sharing their expertise today. As we've seen, AI's role in the courts is growing at a rapid pace, and we can't afford to fall behind. The future of the justice system is being shaped now, and courts must be prepared to lead the way, not just play catch-up. And to you dedicated court professionals tuning in today, thank you for your ongoing commitment to upholding the principles of justice, no matter what the challenge. Your work is invaluable. Thank you. Join us on Tuesday, June 17th, for another episode where we dive into the issues facing courts today. This has been the Court Leaders Advantage podcast series. I'm Pete Kiefer, and thanks for joining us today. Thanks for joining us today. The Court Leader's Advantage is a regular podcast series on courts and court administration. Today's episode will be available on our website, on the Court Leader website, on YouTube, Facebook, iTunes, LinkedIn, and on X, formerly known as Twitter. Become part of the conversation. If you have questions, comments, or ideas for future episodes, email us. Our address is podcasts@nacomnet.org. Did you hear an interesting comment by one of the panelists that you would like to listen to again, but you don't want to search the entire episode to find it? The additional resources section of the webpage has a question time marker sheet. Find the discussion question on the sheet, and next to it is the time that question was asked. You can quickly fast forward to that time and listen to the panelists' comments. Remember, if you don't have time to watch an episode, you can always listen to the audio version. Listen in your car or on the bus on your way to or from work. You never have to miss an episode. I'm Pete Kiefer, and on behalf of our guests, the Court Leader website, and the National Association for Court Management, thank you, and have a great day. The views, information, and opinions expressed during this episode are solely those of the host and the individual presenters. They do not necessarily represent the position of the National Association for Court Management.